Okay. Hello, everyone. I hope everyone is well. Welcome to Legal Updates for today. What I plan to do today, and of course I welcome, to the extent we're technologically capable of doing it, any questions or input. But what I'm going to try to do today is cover some of the new forms that have come down from CAR as a result of the coronavirus. These are basically the COVID-19 forms. And I'm going to try to go through them. There's several forms to get through, and we'll try to address them as best we can. Keep in mind that a lot of these forms came down quickly when the virus and the shutdown orders first became a real issue. CAR, I think, did a great job of scrambling to try to put these forms together, but they were evolving, and they did evolve. And as some of you may know, they changed throughout the time period here. The forms that I'm going to be referring to today basically are dated June 2nd, so about a month old. And I'm not aware of any further updates. If there are, the fundamental mechanics of the forms don't really change, but we can talk about that at a later date. So let's just walk through a typical process of securing a listing, and I'm going to try to walk it through and go through the forms as we walk it through. So with Ed's permission, I'm going to try to share screens.
Yeah, give me 1 second.
I think I've done that.
Cool, you're all set.
Okay, so here's a typical listing agreement. Pardon the water stamps in there. So everybody's familiar with the listing agreement. The listing agreement is the listing agreement, etc., blah, blah, blah. But now CAR has come up with this document, which is called CAR form RLA-CAA. And I'm going to magnify it a little bit. So what we want to do now, when we enter into a listing agreement with a seller, we want to have this proposed addendum or amendment to the listing agreement. Whenever CAR says this is an addendum or an amendment, it means that it can be used when you execute an agreement, or it can be added to an agreement after it's executed. Obviously, we would recommend trying to get this agreement up front. And what this does is it has the usual sort of disclaimers to the seller, the things that everybody already knows, but we need to say anyway. Guess what? There's a worldwide coronavirus, COVID-19 pandemic, et cetera, et cetera, et cetera. And you as a seller should be aware of all these things. And it also says that we as agents and brokers will do our best to comply with COVID directives, and we will try to obey the fair housing laws. Don't directly apply to COVID, although there are some situations with tenants. And the C, again, this form is RLA-CAA, so it's a residential listing coronavirus addendum or amendment. That's where the letter CAA, and this is intended to be part of a listing agreement. So there are things here that your seller can decide what they want to do, and the default under the agreement is that the seller agrees. For example, the seller agrees to allow prospective purchasers to enter the property, or the seller does not agree. Now, this form also refers to something called a coronavirus property entry disclosure declaration, or what we refer to as a PEAD, P-E-A-D, and I'm going to talk about that form in a minute. So as part and parcel of executing a listing agreement, and assuming we're also doing this CAA, we're also providing the seller or occupant with a CAR PEAD form S. Now, to my knowledge right now, there are 3 different PEAD forms, P-E-A-D, there are 3 different ones. One for a seller, and then one that's to be used in a landlord, a lease tenant situation. And I will tell you, we'll go through the form, but they're fundamentally the same forms. It's just that we've got a tenant who's an occupant as opposed to an owner who's an occupant. And the third form is called a PEAD V, as in Victor, PEAD V, and that's a PEAD for visitors, and we'll talk about that in a moment. So you can discuss with your seller what kind of activities they want to do or not do. The form is set as a default that the seller generally agrees to allow these things. And so, it's not necessary to go over this with a fine-tooth comb. I think I would say read this and let me know if you have any questions. And then if the seller signs off on them, then they've basically agreed to allow these showings, et cetera, et cetera. So that's basically the CAA form, and it covers most of the sort of advisories that we have. Interestingly, there's reference in here to some web pages that the client can refer to get more information from the state of California, et cetera, regarding COVID guidelines and connections with real estate. The document also refers to something called a BPP, which we're going to talk about as well. As part of the modern world, businesses are expected to come up with practices and guidelines for how they're going to operate in light of COVID. And CAR has done a remarkable job in this regard. They have come up with something called Best Practices Guidelines and Prevention Plan. It's somewhat extensive. It started off, I think, as 8 pages, and then I think it got whittled down to 5 pages, and now I think they're looking at a 3 or 4 page version of it, which I applaud. But regardless, this document is referred to as the BPP, and this is our guidance and prevention plan. So presuming we get the listing agreement executed, and presuming we get the CAA, the residential listing agreement addendum for coronavirus or amendment, then the next step is you have your seller sign off on the PEAD-S. PEAD-S. This is the PEAD for the seller occupant. Okay, this particular PEAD form is a page long, so that's good. This one, as I said, was revised on June 2nd, and it goes through the same basic things. It reminds everyone that there's a coronavirus situation, that we're going to do our best to comply with it. It contains certain representations and acknowledgments by the seller. It acknowledges that there's a risk of exposure, which is obvious, but it's expressly stated. It acknowledges that there are government orders, and we're going to talk about government orders in a minute, but these government orders apply, and even though we have these CAR documents and these CAR directives, all of the CAR documents, remember, CAR is a statewide California organization. It's not really a governmental entity. CAR is the California Association of Realtors, and it's the governing body of realtors. It's not the government per se. And what CAR does is, in all these forms, it tells everyone that they have to still comply with any applicable law. And we're going to talk about some applicable laws in a minute. Laws in this context are these various stay-at-home orders. And so even though CAR is issuing these statewide advisories and directives for how we should be doing business, they're always going to say things like, let me move this down here. They're always going to say things like, no matter what we say, you still have to be mindful of local laws. And we'll talk about local laws. When the seller signs off on this, the seller or occupant acknowledges that they're going to let people on. It acknowledges that they've been given a copy of the BPPP, and we'll talk about that in a moment. It also contains representations. You understand that there are risks of going on the property. You understand it to the best of your knowledge. You're stating affirmatively, as the seller or occupant, you're not currently afflicted with and have not knowingly within the past 14 days been in contact with someone with COVID. You're not experiencing the symptoms of COVID. And you understand that persons may be afflicted with COVID and they may not have any symptoms, etc. It says that you're going to tell us if there's any health or change in this after we execute this form. If there are any exceptions, you'll tell us now. Obviously, most people are just going to leave that blank. And then there's, by signing, they're agreeing, declaring, and assuming risk. Now, I believe that all these things exist as a matter of law and are publicly known regardless. But we have this form so that it's all clearly stated, and we minimize the degree to which someone comes back later and says, oh, I honestly didn't know that. They never told me. No one's guaranteeing that they're protected, and by signing below, you as the signer are allowing entry to the property, acknowledgement of risks, et cetera, et cetera, et cetera. This document is intended to be signed by the seller owner, and I would say any adult occupant. Now, people say, what about minors? I'll talk more about minors in a moment, but a minor is anyone who is, I believe, below the age of 18 is the definition. And legally, people below the age of 18 are deemed to not have capacity to enter into a contract per se. So technically speaking, getting a minor to sign this document, there's no harm in doing it, but legally they're not of age, so it's not legally they don't really have the capacity to enter into this. There's no harm in asking minors to sign it, but generally speaking, adults who have children or are the guardians or the care providers for the minors, they're deemed to be responsible for this. So I don't believe getting the minor signatures are necessary. If you feel better getting those, by all means, go ahead. But it's intended for sellers and occupants to sign. Now here, these are acknowledgments of receipt, and we all know about these acknowledgments of receipt, and we all know that generally speaking, most of the time people don't initial or sign off on acknowledgments of receipt. We should still document, however, that we have this form. So we want to submit it to the seller. We want to get the seller's signature back. And we want to provide a copy, if necessary, to any buyer's agent or prospective buyer who's going to look at the property. And in theory, the buyer or agent broker for the buyer is supposed to acknowledge receipt. We're supposed to acknowledge receipt if we're the listing agent. They also have here an acknowledgement for the seller's receipt. I suppose that's in the case that an occupant has signed, and we want to give a copy to the seller as well. So we can ask people to acknowledge receipts, but the document says that these don't change the form. In other words, they're not required. The form is still the form, and it's been delivered, and we've got proof of delivery regardless of whether the initials are provided or not. So you can ask people to initial and return to you. I don't know how much time you can spend on that, but you want to keep documentation showing that these forms have been transmitted. So you've transmitted the form to the seller, you've received the form to the seller, you've provided the seller's form to the buyer or prospective buyer. If there's another adult occupant, you've provided each of their PEADs to each other. I can't really say it enough. You can't over disseminate these forms, meaning go ahead and spread them around. And people sometimes ask, do I need to get these forms updated? Well, you know, generally speaking, that's probably not a bad idea, but there are limits to how much people can reasonably do. The signer is representing that they haven't been afflicted within the past 14 days. So obviously, if we're getting past 14 days, say we have a 30, 60, say we have a 60-day listing, and we have a prospective buyer coming in day 45, and the prospective buyer says, you know, I'd like to get a new PEAD signed by the seller. That's a reasonable request. So we can ask the seller or occupant to issue a new PEAD, and we can provide that to the buyer or the agent. There are limits to how much you can follow up on all this stuff, but you should be mindful that these things do get out of date. Now, CAR has a form that is essentially the same form, and it's intended for owners and occupants of lease and rental property. And I will tell you, even though this form spills over onto 2 pages, it's essentially the exact same form. It says basically the exact same thing. So the first form, the PEAD-S, is intended for sellers and occupants, adult occupants, and the second form, PEAD-LR, is intended for owners and occupants. And obviously, you know, a seller owner is likely to reside in the property, but a landlord owner is likely not to reside on the property. And so this would be intended for that landlord owner and also any tenants on the property. Now, I get questions all the time. What do I do if the tenant won't sign off on the PEAD or provide the PEAD? And I'm sorry to say that if the tenant doesn't agree to allow people to come in, if the tenant doesn't agree to take on these risks of exposure, if the tenant is not in writing on board with this, then we as agents can't do anything about that. Our position and policy should be, well, I can't take a prospective buyer into that unit if the tenant won't acknowledge the PEAD LR. And, you know, a lot of people can get a little ruffled by this. An owner could say, well, you know, why can't you do it? I'm telling you to do it. I'm instructing you to do it, et cetera, et cetera, et cetera. And I'm sorry, but our response as a broker has to be, as agents, has to be, well, I'm sorry, I can't do that because the tenant has lawful possession of those premises, and he's an occupant or she's an occupant, and they have to agree. I can't take prospective buyers in there. And if people have questions or concerns, you know, we can deal with it on an individual basis, but that is the standard that now applies to our industry. And I will tell you something else. There's also an LA City order that applies, and we'll get to that order in a minute. So, you know, we really just can't do it if the tenants aren't in agreement. And if I'm a listing agent and a tenant isn't agreeing to let prospective buyers in, I try to turn that somehow into my advantage. I say to the seller and I say to any buyers, look, you've got tenants in there. They're serious. They like living there. They don't want to be disturbed. This is income generating property. And if you have to see it first, I'm sorry. It's not going to happen. But, you know, if you don't want to buy it, we got a lot of other people who are going to buy it. It's valuable property. So, you know, I'll do what I can to try to get you in there at some point, but I can't promise anything. And like I say, if you don't buy it, somebody else will. Now, each of you has to cultivate your own method of dealing with that, but that's my approach. And, you know, there's not much else you can do. They have the right to not permit entry. Now, the next thing that CAR came up with at this time are these posted rules of entry. And this was really nice because I had a lot of agents who were calling me and they were saying, well, what do I post on the property if I'm letting people come in and look at the property? And we didn't have any posted signage or anything like that. All we had was the PEAD form. And I said, well, just post the PEAD form. But CAR, and you know, I'm really very impressed with CAR. I can't say it enough. You know, they don't get everything perfect, but they really do a good job of trying to protect us and give us tools to deal with this. CAR comes up with this sign, and it looks like a 2-page sign. It's nice. It's got red. It's got images. It's got the protective mask. You know, don't touch stuff. Throw it away. 6 feet. Wash your hands. Blah blah blah. You know, all the stuff that people already know. But it's good to have this sign. And so, what you should do is, if you're going to have anybody come onto the property, and I mean at any time, to look at it, assuming the seller occupants have permitted that, you want to post this sign either on the front door or just inside. And, you know, it's just an additional layer of risk prevention. You know, we had the PEAD form sign. We disclosed all the issues. We got the PEAD form sign. We had this sign posted, and et cetera, et cetera, et cetera. I really like this sign. It's a wonderful resource. So let's use it. Now, visitors to the property. So this is probably, you know, the one that I think people deal with the most. This is the PEAD V, PEAD V, V as in visitor. And this should be obtained from each visitor each time they enter a property. Here's what the CAR advisory says. A new declaration should be obtained from each visitor each time they enter the property. So what they're saying is that if you have a prospective buyer come in on a Monday, you need a PEAD, you should get a PEAD V for that day from that visitor. And if that visitor comes back a week later, a few days later, whatever it is, CAR is saying, get another PEAD V. So when CAR says things like this, these aren't laws. These don't govern us as laws, but what they govern us as, this is called the standard of care. I mean, CAR is us. CAR is the California Association of Realtors. So if the California Association of Realtors has decided that we should get a new declaration. That is now our standard of care because that's us. We've admitted as an industry that that's what we should do. So the way this typically comes up is if we don't comply with these PEAD forms and do what we say we're supposed to do, and if, God forbid, anything happens, somebody has a direct claim against us for conduct that falls below the standard of care. Now, I actually think it's going to be very tough to prove that somebody got it on X date by going to the property as opposed to a million other sources, et cetera, et cetera, et cetera. But nevertheless, you know, they can make that allegation. So these CAR documents are what we call the standard of care. This is what competent real estate professionals have agreed that they're going to do. So the PEAD-V sets forth the standard for a visitor. You know, there's a space up here to put the property address. It says here you can have multiple addresses. So someone said to me once, well, I want to take a prospective buyer to multiple places. And they said, can I put multiple addresses up here? And you know, the form itself says you can do that, maybe used for more than one property, subject to getting it updated each time they enter. So it says a lot of the same thing: risk of exposure, government orders, real estate activities, blah, blah, blah. We're going to comply with COVID directives, et cetera, et cetera, et cetera. The purpose of the entry is to viewing or inspecting. Now let's talk a little bit about viewing or inspecting, just so we're clear. Viewing, I consider to be pre-contract activity. Viewing, showing, these are pre-contract activities, meaning these are prospective buyers or agents. There's no contract of sale. They're looking at the property for purposes of seeing if they want to make an offer on it, and if so, how much. I view inspecting as something different. Inspection rights are given to the buyer under the purchase agreement. So we talk about pre-contract activities and post-contract activities. Inspecting, in my opinion, is a contract activity. A buyer has a right of inspection. Now, the seller may say, well, I don't care if you have the right of inspection. I'm not going to let you physically go on the property. You're going to have to decide if you want to buy it anyway. Nothing we can do about that. But that's the difference between viewing and showing on the one hand and inspecting on the other. The same PEAD-V applies. It doesn't matter why they're going on the property. Each person, each visit should get a PEAD-V to sign, and we want to provide it to everybody. We want to provide it to the seller owner, any occupants, the listing agent, the buyer's agent, etc. So it's got all these advisories, same thing as before: practice social distancing, don't touch your eyes, ears, nose, blah, blah, blah. Signer acknowledgments. You're not going to do certain things, bring certain things. Posted rules of entry, that's what we talked about. That's the sign. It talks about these websites. Whoops, sorry, I didn't mean. You click on it and it takes you to a link, and the link is blank. So, but I assume if you pasted that into your browser, you'd go there. It talks about the BPP, and most of these forms, when you pull them up on your system, they include the attached BPP, which is what I refer to. These are the best practices guidelines. This visitor form also contains a provision about minors, and it talks about what I said before, which is that adult signers acknowledge and agree that all property entrant rules, signer acknowledgments, and signer representations apply with the same force and effect to any accompanying minors as they do to the signer. Signer is responsible for their care and safety and conduct on the property. Any accompanying minors shall be identified in paragraph 8. So this comes up typically where a prospective buyer says, well, I want to go, I want to look at it with my spouse, my significant other, and we want to bring our 2 minor children with us. Well, the correct procedure is to say, okay, buyer, if you want to bring your minors, your children, fine. Just remember, you're responsible for them, and please give me their names. If they show up with their minor children and they haven't told you in advance, you should have these additional forms ready to go. Now, you know, if the buyers have already signed this, then the buyers have already agreed to be responsible for minors. You can ask to get the minors' names so that you can put them into the form, etc. It's not a huge deal, but you want to be mindful of these issues. The adults who are bringing children are responsible, and you might want to tell them, look, I understand you want to bring your minor children with you. These days, we're trying to limit traffic into the home, and these days, we recommend that if you really don't need to bring them, you don't, or alternatively, you sort of stagger their entrances. Maybe one adult takes one child and then another adult takes another child. You look at them separately. It's hard to really micromanage these things and give you concrete guidelines and rules. You're just going to have to juggle it accordingly. And I realize that lots of times it's just going to be like, well, I can't control this. All I can do is just get these people to sign PEADs. And that may be all you can do. We're just trying to make you aware of everything. Now, the BPP is a kind of significant document. And the first thing it says is check your local orders. And don't forget, as I've said before, CAR is not per se the government. I think they work hand in hand with the government. I think they lobby the government. I think the government relies on CAR to give them input as to what kind of orders and legislation the government wants to do. But CAR is not the government per se. CAR is an association of realtors in the state of California. They govern our standard of care. They govern us, but they're not the government per se. So if your local city or county have issued more restrictive orders than CAR is telling you, you got to comply with those orders. And remember, CAR has got cities and counties up and down the state of California. So they're not dialed in to LA city orders. They're not dialed into San Francisco city orders per se. I think they're aware of them, but they're telling us it's your job to comply with the local orders, not ours. Okay, so a lot of stuff here. I can't go through it all, but it repeats a lot of the same things that we've talked about. Visitor admonishments, visitor guidances, risk signs, warning signs, et cetera, et cetera, et cetera. Let's see. Blah, 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 blah. There was something in here. It says here, and this is something I don't really agree with, but this is what it necessarily says. It says that the listing agent or brokerage firm has ultimate responsibility to ensure that the property is cleaned and disinfected before and after each showing. So I think that was a concession that CAR made to get approval for real estate activities being deemed essential activities and exempted from some of the orders. But we are agreeing that the listing agent is responsible for making sure the property gets cleaned and disinfected. It's an unfortunate burden, but it's a burden. And the listing agents are going to have to do that. And they're going to have to make best efforts to try to keep the property cleaned and disinfected. Now, it doesn't say who's responsible for payment. You can tell the owner, well, I've got to get a cleaning crew in there. I'll spot clean it once a day. I'll use my wipes or whatever I got. But you're going to have to pay for a cleaning crew to come in there on a regular basis. No, I don't know. Those are micro details that you're going to have to navigate. But those are the general rules. Now let's see. There was something else in here.
Peter, did they give guidance on how to clean it? Like what?
Yes, they do. It's down here. Sanitation protocols, responsibility for cleaning and disinfecting protocols. I mean, it's extensive, and we're not home cleaners, but it's in there. Clean the properties, clean the places that are frequently touched, all this stuff. Provide time for cleaning practices. I mean, have hand sanitizers available, face coverings, yes.
Do they want, well, a couple questions. When they say after each showing, is that after each day that you may have multiple showings on that day? So after each entrant, then you have to go back and clean for the next entrant to come in? Is that what that means?
That's the way I read it.
Okay, so every group of people that comes in, then we're supposed to go behind and clean, which really wouldn't be a cleaning crew because that wouldn't make sense.
Look, unfortunately, my job is to not view these things broadly and loosely. I have to advise that we should try as much as possible to apply with these things in the narrow letter of the document sense. So whenever anybody asks me, can I do this or that, I'm almost always going to default to the narrow position. It says showings. It doesn't define showings. I view showings the way you viewed them, but I also think there's some sort of reasonable limitation. You know, if you've got people scheduled to come through during a 1 hour time block, you've got 12:15, 12:30, 12:45, and 1 o'clock. I'm not sure how you can really clean in between that. You're going to do what you can, but at the end of the day, then I think, you know, that's when it's talking about, you know, getting a cleaning crew in there or something. But I can't change the wording, and I interpret the wording the way it is. I interpret showing as showing. Now, some people may interpret showing a little bit more broadly, and I can't dispute that. You're just going to have to use your best reasonable judgment and decide what is and is not a showing for the day.
And
Can I
does,
ask a question?
are we released from liability if?
You're never released from liability.
Okay.
Go
So
ahead.
let me rephrase that then. I post, and maybe you can't answer this because you're interpreting directly, you're going directly off of this form, but we post that, you know, enter at your own risk. Basically, we will not be cleaning after every showing, and we have posted that. Is that?
No, I don't believe that's what the CAR posted guidelines say. And
No.
I don't believe we should be posting that we're not complying with what we think we have a duty to comply with. That doesn't protect us. That actually exposes us.
Okay.
So post the guidelines, stick to the rules. I know they're hard to comply with. I can't tell you that you absolutely positively better dot every I, cross every T, but I certainly can't tell you that you can just disregard it and post signs saying you're not going to do it.
Okay.
That isn't going to protect you from liability. That's going to expose you to liability.
I have two questions. What if when you tell people to come in, you say, please do not touch anything. I will open everything for you. I will touch everything for you. And they don't, and they do listen and they don't touch anything. Am I still legally required to go clean after them?
First of all, you have to understand, you can't control people, okay? You can give them directives and suggestions and guidelines, but you can't control people. People are going to do what they want to do. You're going to have to do your best to do it. Am I still legally responsible? Well, I'm defaulting again. There is nothing you're going to say or do that's going to completely shield you from liability. Liability is ever pervasive, and it doesn't even have to be based on the truth. You say, I told them not to use the toilet. They used the toilet anyway, and now they're suing me. And you say, I swear to God, I told them not to use it. And they say, no, she didn't. You know, you can't protect yourself from liability by trying to micro control these people. And people typically can't be controlled. It's an illusion. Exercise what control you can. Do what's reasonable. Be professional. But you can't make people do or not do something. I mean, you've seen the world out there. There are some places that say you got to wear a mask. I mean, good luck. Okay. You can't control people. All you can do is try to be reasonable, and try to do the best you can. Try to stick to these guidelines. Try to control the amount of traffic that goes through these places. Try to have situations that are reasonably manageable. You got to do the best you can. And that's all we can ask. We don't want to just ignore these things. And I think it goes without saying, it's going to be very hard to live up to every single line and item here, but we got to try to the best of our ability.
Yeah, but they're all wearing gloves at the same time too. So it's like, how many layers do we put on top of the, you know, we're already doing that.
If you're looking for me to give you a concrete answer, I'm sorry, I can't do it. You're dealing with a rule of reason, a rule of reason. This is the real world. These are guidelines. This isn't the law. These are guidelines. As agents and brokers, we can be sued for anything, and anybody can file a lawsuit in court. They can say whatever they want. And that bullseye is always on our back, and it's not going away. All we can do is minimize risk, be reasonable, post the signs, get the form signed, try to control behavior. but I personally have found in my life that the more you try to control someone, the more you lose control over them because they resist it. So you guys are all independent contractors, licensed professionals. You're at what I call the point of attack. You're there on the front lines. It's difficult. It's tough. Nothing's perfect. Everything's flying all over the place. Do the best job you can. These are the rules. We got to try to apply them, abide by them as best we can. And, we'll see what happens, but we're going to do our best to live up to these guidelines.
Okay, I have one final question. I took someone to see a property that in the instructions, because it was on Supra in the Valley, the agent said all buyer's agents must do the cleaning and disinfecting after they leave. They have to commit to doing that. Can they do that if they're the ones responsible?
People, this is one of my favorite questions. I get this all the time. Can they do that? They can't do that. Can they do that? They can't do that. And I'll say it again. People can do whatever they want. Here's the problem. How is that going to be enforced? I can have you sign a document that says, I agree to be responsible for this. Can they do that? Well, they just did. There's no invisible barrier that says, you can't do that. They just did it. They handed you the document, so it's done. So the technical answer to your question is, yeah, they did it. What happens if you don't abide by it? Or what happens if you don't sign it? Well, I think one thing they're saying is if you don't sign it, then you're not going on the property. And there's nothing I can do about that. I'm not sure there's anything you can do about that. The second thing they're saying is, well, you signed it, but you didn't live up to your promise. And you'll say, that's right, because I don't think you can enforce that. And you wouldn't let me go on the property unless I did it. So I'm not doing it, and goodbye. Now, I don't know what happens. I don't think there's a real enforcement mechanism, but I can't stop someone from saying, well, we had to hire a cleaning crew and it cost us $200 and she said she'd do it. So boom, small claims against her. And I express no opinion about the outcome of that. Moreover, I don't express any opinion about, well, she said she'd do it, she didn't do it, and we're not going to ever deal business with her again. Unfortunately, there's just not a lot I can do in the free-for-all of people going back and forth out there in the field. And there's a lot of stuff that goes on that shouldn't be going on, but it's too hard to manage and police and enforce and deal with. So, you're going to have to pick and choose your battles just like everybody does. And you're going to have to decide if you're going to agree to that or not. You can sign it, cross it out and say, I'm not doing that. That's your job. That's what the BPP says. And I'm sure you'll have some slick listing agents who says, yeah, the BPP says it's my job and I'm delegating you to do my job. And, human behavior is slippery. People are always trying to get around stuff and there's nothing I can do about it. It is what it is. That's the overview.
There was a guy from Compass today that, I don't know if you saw him, Inman, that was thrown out of Compass in Altadena because he didn't let people know that the owners had COVID. And he's claiming he didn't know, but he's put out some Facebook message or someone did warning anybody that came to this house during this certain period of time needs to know that the owners had COVID. It was just in the news article today.
Well, I'm very glad that he was kicked out of Compass. And that's just another example. Sometimes people take the view, don't tell me, I don't want to know. Don't tell me, I don't want to know. Hear no evil, see no evil, speak no evil. And I can understand that. But when you have Facebook posts saying, watch out, these people have COVID and I'm the real estate agent, and then you go around saying, come on in, everything's fine. I think that's inappropriate behavior. You're knowingly putting people at risk. They're at risk. You're not telling them. I think that's inappropriate. I would recommend, if all those facts are true, I would recommend, terminating a broker relationship with that associate as well. I don't know all the facts. But another red herring, if you will, or red flag is what I meant to say. Red herring is what most people chase and it's irrelevant. Red flag is a sign of suspicion. If you're visiting a property with a prospective buyer or in any context, you want to ask for that seller PEAD. And the seller in the PEAD would have said, I swear to gosh, I don't have these symptoms. So people disregard that, but you'd want to ask for that. Now, you can't make the seller give it to you. But you can tell your buyer, look, the seller refuses or declined to execute a PEAD form saying they don't have it. And I don't believe that they do, but I don't know for sure. And you, Mr. Buyer, Ms. Buyer, I don't know. So it's up to you if you want to go on. And you have to decide if you're willing to take that risk. And, you know, unfortunately, that's the world we live in. And all this stuff can happen day in and day out. It's very unfortunate, but that's the world we're in.
Peter, in reference to that PEAD-S that you just talked about between a listing agent and the seller, should we be getting a newly signed PEAD-S every 14 days?
Well, just to be clear, the PEAD-S is a representation by the seller. The listing agent does request it typically, but a buyer's agent can request it as well. Buyer's agent can say, look, I haven't gotten a PEAD-S, have your seller sign this. So you might have a PEAD-S that was executed by your seller 21 days ago, and a buyer's agent may want to come in today, and he or she may say, well, listen, my buyers and I want a new PEAD-S from the seller. So that's a good way of dealing with that. You can ask your seller to refresh the PEAD-S as often as you want. And let's see, is there a 14-day provision in here? I don't know if there is. Hold on.
I thought there.
I think you just passed it. 4B2 or 4B1.
I don't see. Oh yeah, 14 days. Okay. So look, that indicates that this form is out of date after the passage of 14 days. So that indicates that it should be refreshed every 2 weeks. Now, you know, that's the standard that is now imposed upon us. So you can say to your seller, look, seller, sorry to do this again, but these forms get out of date in 14 days. So I got to ask you to do another one. Thank you very much. And, you know, you can't make your seller do it, but you can certainly document that you tried. And you can certainly say to a buyer's agent, I've asked, they haven't done it yet. I think they hate those forms. You know how it is. It's up to you. What do you want to do? If you want me to ask again, I'll ask again. You know, I'm not a big fan of hunting people down and hounding them for stuff. I am a big fan of making the request, documenting it, having something there that I did it, and then moving on, because I don't have time to chase people down. And I don't like to have to repeat myself over and over, but everybody's different, and I defer to each one of you how you want to proceed. But to me, I think I would do it every 14 days. Dear seller, it's been 14 days since our PEAD. As a matter of our policy, I'm asking you to execute another one. Here it is. Grateful for your cooperation. I'm sure this will put the buyers and the buyer's agents at ease. Looking forward, we're making good progress. Thank you. And then I start doing all my other stuff. All right. Now, let's talk about something that I don't think anybody really wants to talk about, but let's talk about, where is this? Let's see here. The LA City order. Hold on a minute here. Give me 1 second. I have to find the LA City order, and I have to adjust things here. Forgive me. LA City stay-at-home order. Okay, great. This is the LA City order, and this is us. And I'm sure a lot of people have seen this before, but I'm just going to run through it again. And I'm going to remind everybody of this order. There's an LA County order, and I think the LA County order says something similar. But the LA City order is a little unique. They're a little bit more comprehensive. And as I said, this is the order that was updated June 29th. I haven't checked to see if there's a new one. The way the world is going right now, I wouldn't be surprised if we get new orders, you know, in the next few days or weeks. But, you know, this order has been revised several times. Now, we talked about city and local orders, and we're the city of LA, and we're squarely within the compass of this city of LA order. And you know that there's this paragraph about essential business activities, and these business activities are generally exempt, but they're not just exempt in an unlimited sense. There's a price tag to exemption. And here's the order provision that generally applies to us. The essential businesses that are exempted include office-based businesses, when teleworking is not possible, including professional services such as legal, me, leasing, real estate transactions, payroll or accounting service, when necessary to assist in the permitting. Now, permitting deals with LADBS construction permitting, inspection. Now, inspection is what I talked about earlier. Inspection is not showing per se. Inspection is a buyer's right with their hired professionals to inspect the property. So I view inspection as a contract activity, not a showing or viewing. Transfer and recording of ownership of housing. Well, that's just a fancy way of saying real estate activities, but transfer and recording of ownership and housing is part of a contractual activity. Technically speaking, showing and viewing is not subject to this exception, technically speaking. Now, I know what's going on out there. I'm just telling you, this is what the LA City Order says. And when necessary to achieve compliance with legally maintained activities. Now, here's where it gets down to particular stuff as to us. The June 29th LA City Order says, housing units and real property may be shown provided that appointments and other residential viewings, that's pre-contract activity, occur virtually, or if a virtual showing is not feasible, by appointment with no more than 2 visitors at a time residing in the same household. That means that the 2 visitors are both part of the same household, you know, spouses, adult, child, whatever it is. 2 visitors at a time from the same household or living unit, and 1 individual showing the property. That's what it says. Note that it says that you're only supposed to do in-person viewings if virtual viewing is not feasible. Well, I'll tell you my take on that. Everybody says it's not feasible because no buyer is going to make an offer unless they go in there and actually look around. So everybody is taking the view that virtual showings are not feasible. If you're publishing a virtual tour, you're demonstrating that virtual tours are feasible. I'm not discouraging that. I want to encourage that, but be mindful that you're admitting that a virtual tour is feasible. But I'm not terribly concerned about that. These orders, despite this language, this is an order. This is a city order. This is binding on us. It directly applies. This is exactly what Carr was talking about when it says you got to comply with a local order. I recognize that nobody is complying with the virtual only showings. They're just bypassing that. And, you know, I don't think anybody's going to come in and cite us, fine us, or subject us to some sort of misdemeanor charge. If you have a published open house and you've got a bunch of people in there and you're just basically making a spectacle of it, I'm pretty certain somebody's going to call somebody and you're going to get written up. And then you're direct violation of that order. Now, here's the bottom line, literally. In-person visits are not permitted when a tenant occupant is still residing in the resident unless the owner first obtains the tenant's written consent. Well, that goes to exactly what I said earlier. So it says that we're not supposed to have any visits to a tenant occupied residence unless the owner first obtains the tenant's written consent. Now, we can obtain the consent on behalf of the owner with the PEAD form, the landlord-tenant LR form, but we have this order and our policy that says, well, we can't do it unless the tenant agrees. And if the tenant doesn't agree, the tenant doesn't agree. That's it. I mean, not much you can do. So don't try to violate that. There's an LA County order, and it's very similar to this, but the LA County order actually says that you can't do in-person visits when the residence is occupied. Okay, that's what the LA County order says. And so that's even broader. LA City said, no, it just applies to tenants, but LA County says it's not supposed to be done if the residence is occupied. I will tell you again, nobody's strictly complying with that order. I do think people are strictly complying with the tenant consent part. I don't think people are strictly complying with these other provisions. Nevertheless, you need to be aware of them. You can't flaunt and completely disregard them. You want to be mindful of them and, proceed accordingly. We should be fine as long as we get all our PEAD forms signed by all proper parties. But if there's an issue and somebody pushes back, like a tenant, nothing we can do. Buyer's either going to buy it or not. It's not our job to break down the tenant's door, make them comply, etc. Personally, I would be grateful if a tenant said no, because that's one less thing I have to worry about. That's my opinion, but I understand you guys feel differently. Okay. A lot of stuff, blah, blah, blah. Apologize. I will try to answer as many questions as I can right now. What do you got? If anything. Did I suck the air out of the room? That happens a lot.
My questions were answered. Thank you.
Well, I do my best. Thank you all.
What if the property is vacant?
If the property is truly vacant, then the LA County order doesn't prohibit that, and the LA City order does not prohibit that. There is still that language about virtual viewing, if not feasible. Everyone's just bypassing that. But if it's truly vacant, then there's nothing other than the feasible visibility of virtual showings. There's nothing that prohibits a showing of that property or a viewing, but we still got to get the PEAD forms.
Still got to get a PEAD-S form from the seller?
We want a PEAD-S from the seller, and we want a PEAD-V from the visitor.
Right, right.
And I will tell you that, again, the PEAD-S and the PEAD-LR, as far as I can tell from an eyeball look, they're basically identical, but one is specifically tailored to tenants and owners, and the other is tailored to sellers and occupants. And so they're just trying to keep that labeling distinct. Whoa. Are you exhausted? Is everybody worn out? All right, well, you guys know where to find me. Call, text, email, carrier pigeon, whatever you got. I'll do my best. Remember, my job, unfortunately, is to not help you get around these rules. It's to tell you to comply. But I'm happy to answer any questions you've got. I know it's hard out there. I'll say it again. We just got to do the best we can. And I think you're all doing a great job. These are strange days, but we're all getting through them. And hopefully there'll be some light at the end of this tunnel. I think that a lot of these practices are good practices. And when this period ends, a lot of these things are going to be a part of our lives. And so we're going through an educational transition period now, and it's probably ultimately for the best, although it's these are growing pains and they're a little uncomfortable.
Hey, Peter, we have some folks asking for your email address in the.
Okay,
you can put it
here's
in
my
the chat.
email address. My name is Peter Haven, H-A-V-E-N, Peter Haven. And my email address is peter@havenlaw.com. peter@havenlaw.com. Oh boy.
Well, this was excellent. I mean, I've got a book full of notes here. If anyone who's wondering, we did record this call, so we will have it available on our YouTube channel. So if you want to go back and listen to it, or if you missed a detail, it's available to you.
You know, my motto about YouTube, apparently anybody can be on YouTube. I'm living proof. All right, folks. I'm playing with a light that I got here to see which shade I want to do. I'm trying to become more presentable because basically I've been reduced to a two-dimensional visual image. So forgive me. I wish everybody the best, and let me know if you got any questions or need any help with anything. You're all doing a great job. Thank you all. Thank you all.
Thank you, Peter.
Thank you.
Take care.
Thank you.
Okay.
All right, bye, everybody. We'll see you all soon.
Bye.